I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go. Welcome, especially anybody that is joining from Courtroom Confidential Trials Live. Thank you all so much for being here. This is a pop-up live. I am recording from my office at work. So I normally record from my home office. Today, trial was just so, and I've been between clients, catching up on things, and wow. This morning, this whole case is summarized down in the description. Ebony Parker, you'll also hear her referred to as Dr. Ebony Parker. She was the assistant principal at Richneck Elementary School back on January 6th, I want to say of 2022, when their reports came to her that a student might have a gum. And I'm saying that wrong on purpose. And the state is pretty much presenting that she did nothing personally. That a teacher searched his bag, a school counselor offered to check his person, and her thing was to wait until the parent got there and then handle the situation. Somebody from HR testified today, and we will get into that a little bit more later. It opened. So when yesterday closed, we knew two jurors had a question, and one of the jurors stated their question out loud in front of the jury. And their question was, if we're unclear about what we're not allowed to consider, can we get clarity on that? I am paraphrasing. That's not exactly what the person said, but that was asked in front of all of the jurors. And so today, juror number 38 and 33. So the female juror was brought in. So she wrote out her question, and they were able to kind of consider it. And her question was something to the effect of so she just had questions about, did the VP make a 911 call? She wanted clarification on the 8 counts. And pretty much the judge told her to rely on her memory and any evidence that's presented at trial, and that the judge cannot answer any specific questions, and that they did also ask her if she discussed her question with any of the other jurors, and she said no. And I think the defense wanted this juror thrown out because I think they know that Dr. Parker did not call 911. I don't know that for sure, but there's no evidence that Dr. Parker called 911 even after there was they knew a pew pew had went off, and so there's no indication that Dr. Parker called 911 that I'm aware of. I could be wrong. But and uncivil law is here, and Kurt, if you did not look at the beginning part, because both the state and the defense, my understanding of what I heard, both the state and the defense wanted a potential mistrial. And I think the state would love to redo some things and would love to have some of their first witnesses have a redo, because I honestly think a mistrial could possibly hurt Dr. Parker's defense, because the state now knows that she's trying to push the blame on everybody else. That the teacher should have done this and they should have done this. And it's kind of like, it wasn't only on me, but as the administration and as the individual that did not notify the principal, she never notified the principal. I think there's a potential problem there. But then we get to juror number 33. Okay, so that was a male juror. We can only hear his voice. And he's the one that asked the question in front of all the other jurors. And they clarified that, and I could be getting their numbers wrong. I hope, because one of them is female, one of them is male. I know it's 33 and 38. So the male juror asked the question. So he asked the question about what if they're confused about what they're allowed to consider and what they're not. The judge, and also he had a notebook. So they had to go back because he had brought a notebook the very first day. He submitted that notebook to the court because they just wanted to make sure that, because they did not provide them with notebooks until after opening statements. The jurors were not able to take notes, or they did not have notebooks during opening statements. And he clarified exactly what was in his notebook. And yes, okay. But this juror stated his question about that some things were confusing and in front of the other jurors. And that's where I was having question marks. Remember, I'm not a lawyer. On civil law in the comments, he is the lawyer. But like the fact that, because jurors are not supposed to discuss anything about the case before they go into deliberations. So even a juror mentioning, hey, I'm kind of confused. Like, what are we allowed to consider this or not? And none of the jurors responded. None of the other jurors said anything, but I would have appreciated if they had voir dired all the jurors about, you heard his statement. Did it have any effect on your views of the trial so far? Because they did not voir dire the rest of the jurors. They didn't. And I thought they might because all the jurors heard his statement. And I'm pretty sure for his appeal, so if for some reason Dr. Parker is convicted, I'm pretty sure her defense team is going to possibly have an issue with all of this. Y'all correct me in the chat if I'm wrong. I don't think either one of those jurors were dismissed. They have two alternates. And so neither one of those jurors were dismissed. And I don't think they've made a decision yet. I could be wrong. I don't think so. Those two jurors are still on there. Okay, good. So good. So Kurt, please go back and so I'm not having a problem having questions if they are confused. That isn't talking to each other. I would be interested if the answer to the question about what they were allowed to consider was bad. So I don't think the answer. So the judge's answer, I didn't take notes on that part. Because I was just so thinking that they were probably gonna get a mistrial, and they weren't. And so I think they were looking into possible juror misconduct. And so because the defense, I think, believes that there is potential, because I think the defense argued that the one juror that's questioning, did the vice principal make a 911 call? The defense was questioning, is that juror starting to form an opinion about the case? And then the potential juror misconduct of the one juror asking the question to the rest of the jury. And so that's what came out. Remember, I'm not a lawyer. I do hope that Josh Ritter or somebody else takes a look at that, and then we'll break it all down for us. It could have been fine because the judge went and looked at the law, and the judge came back and said that, nope, we're good. She put the reason for why she continued, that jurors are allowed to have questions. There's nothing wrong with them having questions. The Commonwealth allows for jury questions. They normally just don't do it. So there are some states that automatically, after a witness stops, sometimes they'll automatically ask the jurors, like the jurors will write down questions as the witness is talking, and they pass them in, and they read the juror questions, and they decide if they can consider any of those. My office is right next to the hospital. So if you hear ambulances, people are just getting safely to the hospital. If you hear ambulances in the background, okay? So then the very first witness today was the HR director. And there was a Zoom recorded call, an internal investigation by the Newport News school system about the incident. And she interviewed numerous people and recorded it on Zoom. And so they voir dired her first to see, could she could they play it for the jury? The state is going to enter the entire video, but the state had clips. And with those 2 clips, we hear Dr. Parker denying knowing that the student was a risk and that she was doing testing that day. And she did become emotional because so we haven't seen much emotion from her. Um just in but in court, she's been the defendant. So she was a defendant in the civil trial, and then she was a defendant in she's a defendant now. And so I think she's managing her emotions and her response. But in that video, I did notice 2 times where there was some emotion. She mentioned that the student JT was struggling with following directions. He was disruptive. He was difficult, and that the Miss Werner, the teacher, was the teacher that ended up getting shot. That she never expressed concerns about feeling unsafe. That was Dr. Parker's testimony. And Dr. Parker, no, not testimony. This was what was said during that interview. And during that HR interview, Dr. Parker also mentioned that she directed Miss Kovac to check the bag. And I think Miss Kovac just said, "Hey, I'll go check the bag. Do you have a problem with it?" Like I don't, but she said during the interview that she told Miss Kovac to check the bag. There was nothing in the bag. And Dr. Parker did not tell the resource officer. She did not tell the principal. The defense objected at some point, and they had to talk. There were lots of talking objections. I think this courtroom is odd where I don't know that they can approach the judge. So I think that's why there's so many talking objections, and we're hearing everything often in front of the presence of the jury. They have excused the jury to voir dire witnesses. They have done some things today outside of the presence of the jury. But I think the courtroom, because when they were trying to give the judge something, it's like they can't approach the bench. Like they have to go over to the side where the witness is. And so I think this courtroom just has a weird outlet. Yeah. So the judge is barricaded in, so there is no availability for a sidebar. I wish they could do an audio, but I think people could probably still hear what was being said. I don't know, but it's not a great courtroom layout. Just my own personal thoughts. Great safety for the judge, but not a great courtroom layout for lawyers to be able to approach. If they find her guilty, does it have to be on all 8, or could it just be for the one used? I remember I'm not a lawyer, and I think that'll be up to the jury. So I think it'll be up to the jury. And then also I think for sentencing, I think the state. So the only reason why there wasn't more than one was because the pew jammed. So the only reason why the student did not fire more than one time is because it jammed. And I don't know what testimony will come in, but we are all very thankful it's that the pew jammed. Okay, all right. Is it a matter of assistant principal not taking it seriously or not being quick with their response? So the assistant principal didn't do anything. And we're going to get to that finding from she never left her office. She never notified the principal. So the principal of the school was not aware that there was a report of a weapon. The resource officer, who wasn't on campus, but nobody was notified, she just continued doing testing. And it's in the HR notes that she communicated with the principal about other things, but did not communicate with the principal about this. That's what's in the HR notes. We'll see. We'll see. We'll see. All right. And so let's see. With HR, they talked about mitigation. So they start reading from one of the county handbooks that was in effect at the time of this event. and it mentions early warning signs and imminent warning signs that require an immediate response. And if there's a sequence of overt behaviors, usually imminent warning signs, and they list a bunch of imminent warning signs, uh, and that safety must always be the first and foremost consideration. Now, please know these handbooks are written with like they consult lawyers and they're looking at mitigating risk. Like that's what they're looking at doing. And they bring up the lawsuits against the Newport News public schools, and I thought all of those were thrown out because I thought the public school system had sovereign immunity. So I could be, if there's something else going on that I'm not aware of, but each one of the parents have been asked about any pending lawsuits. And it was my understanding that I thought they were all thrown out. I could be wrong, but they might be suing Dr. Parker personally versus suing the school district. Because the families were not able to sue the school district. It was my understanding that that lawsuit was thrown out. That's never going to come in. Okay. So we are not jurors. We know more than the jury knows, but I was thinking about that in the back of my mind. If my camera shakes a little, my bad. And so they're suing her personally. Okay. All right. Yeah, and so because I know the former teacher, the teacher that was that ended up having a physical injury and emotional injury from this incident, Miss Werner, she tried to sue the school district because she didn't only sue Dr. Parker, she also sued uh, the Newport News Public School District, and I think the superintendent. I could be wrong if it was superintendent as well. But they were dropped from the lawsuit because of sovereign immunity. And I'm guessing on the parents, I'm guessing that they'll probably be dropped from that one as well. Yes, it jammed, and because he wanted to fire more shots. A 6-year-old, unfortunately, I mentioned that in my last video, they don't understand the finality of death. This child also grew up in a home where, according to reports, it's my understanding that there was exposure to DV, that there were major things going on in the home. The JT, the child's mother, was arrested, and she did serve 3 to 4 years. I've heard 3, I've heard 4 years. And so she was charged because she left a weapon unsecured. And there were some allegations, because I've seen reporting that she was supposed to be at school. There was a plan where the new one-to-one for him was supposed to be a parent, because they're going to bring up that the one-to-one, it went from being Mr. Rawls and then it not being Mr. Rawls anymore, the school counselor. But it's my understanding that it was supposed to be a parent. And now, like, if you have a parent, most parents can't do that. This child likely needed intensive supports. Social services likely needed to be involved. There were likely major issues at home. And based on everything that happened after, we know that there were things going on other places. So I think that's why some people have mixed feelings about Dr. Parker being held responsible, but that's where we expect administration to do something. And it was hours. It wasn't like there was a report of a weapon and 5 minutes later something happened. It was like 2 hours before something happened from the first report. That's my timeline. That isn't the official timeline. This is Richneck Elementary School in Newport News, Virginia. Okay. Richneck Elementary School in Newport News, Virginia. All right. And so the child received treatment. So the child was removed from his family's care and likely was placed in a residential, which is like an inpatient hospital setting, to receive intensive therapy. And then I believe he was returned to the custody of a family member. That was not to my understanding of what's happened. Yeah. I don't think it was that short. I think it was because it was like recess. They came back. It was at least an hour. I thought it was longer. I thought it was like an hour and a half, almost 2 hours. And even if she was doing testing, SOL testing, if there's a pew pew on campus, nothing else is more important. And that came out in the civil trial, I think, very clearly. I hope that comes out more clearly here. I do think she might take the stand. So put a 1 in the chat if you think Dr. Parker might testify. Put a 2 in the chat if you don't think that she'll testify. Because the video of her interview with HR came in, I wonder if she'll want to testify. I wonder, because I'm sure she has some thoughts. Now, her defense team did make sure that the full video was entered, and they made the comment. And then I think that, but they made the comment of, because they wanted to ask if she was, that if she was aware that like, was she advised of her rights? Was she advised of her rights to remain silent, that she could have an attorney present? And because it was HR, I don't think she was advised of any of those things. If she was a part of a union, the union probably would have provided her a lawyer. Sometimes people act quickly on these things and they don't reach out to their union rep, because she did end up losing her job as a part of this. And so, yes. So I think there's a chance that, and once again, it's the content creator in me. So she should not take the stand if it's not helpful. Like, she'll discuss it with her team. And if she gets on the stand, the state gets to truly go in, dig in deeper into what did you know? What did happen? The state would get to ask more questions, and the jury would get to see how credible they found her. It might be in her best interest to not testify. I don't know. Not a lawyer. All right. So with other aspects recapping today, the HR specialist also talked about sometimes a part of the plan might be to reach out to Child and Family Services, law enforcement, and if a child has been dangerous in the past or has a weapon, that these are all part of warning signs. The defense asked the HR specialist about, was it an independent evaluation? Did she look at videos from the school? And then that's where the state objects, because I don't think they're trying to include, I don't know. So like there was a whole thing about him wanting her to testify about things that she might have seen on videos, and it's not in evidence. And so the judge did not allow it. The defense asked the HR specialist, can a student be removed by a teacher? She said yes. And then clarified that the school findings are not legal findings. And they went back and forth because the defense wanted to ask her questions about the findings of the investigation. So then the state on redirect, they're like, hey, let's take a look at the investigation report. Defense objects. And the judge allows the cover page and the last page, because the defense objected based on hearsay, because I think there are things that were reported by other people. And so the judge allowed the first page and the final page. And what was stated in that summary, I took some notes on this. Several employees were told that the student had a weapon. These were reported to Dr. Parker. Inquiries were made to search the backpack. Ms. Kovac searched the student's backpack. Ms. Kovac was a reading specialist. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke with the principal, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling another search situation with another student earlier in the school year, where she brought a student into the office to be searched with an adult present and or the police present. Dr. Parker never left her office on the 6th to pull JT into her office due to testing, which is not, like, that's not, okay. Multiple staff members all had knowledge that the student had a weapon prior to 2 p.m. So this incident, I think, occurred at 2 p.m. And because this started around 12 p.m. because it was right around lunchtime before they went to recess. Failure to detain the student and conduct a search when first notified, and lack of urgency, lack of training and knowledge for the staff. And so those were some of the highlighted words that I realized that like stood out to me from that. Um, the defense wanted to draw out that multiple people failed to search the student, and that there was, and the defense also pulled out that lack of training and knowledge of the staff about how to handle a threat was one of the conclusions of the school's investigation. And the defense also tried to point out the fact, like, are y'all trying to pin this on her so y'all are less liable? And so the defense is appropriately attacking credibility, but and so lots of people have different opinions that not leaving her office is gross misconduct and a violation of policies and procedures. Based on the law, a felony child, um, I guess the state believed that they had enough to at least do that. Is it admin who needs to give permission to principal VP to do a personal search? I thought they were admin. Yes. So that was confusing. And the HR person tried to clarify that. And I think the defense might want that to be confusing. So when it says admin, that is because she tried to say admin is principal and assistant principal. And the defense asked, don't they need permission from somebody above them? And there were some objections, some talking. There's too much talking. And so the principal or assistant principal could have searched the student. They often want somebody else there when they're doing it. If there's suspicion of a weapon, generally you would want a police officer there. I think that student did not want to be searched, and he could have become very aggressive if somebody had tried to take it from him before he had done. So in my mind, he came in with homicidal intent. I think he intentionally brought that weapon. So 2 days before, this incident happened on a Friday. On Wednesday, he broke Miss Zwerner's phone, his teacher's phone. He like threw it on the floor, the screen cracked. He and he ends up not coming to school on Thursday. In his first day back to school, he brought the weapon, and the only person he targeted was her. And Dr. Rawls, no, it's not Dr. Mr. Rawls, during his testimony, he talked about how JT seemed really calm, like oddly calm. And as a clinical psychologist, in the back of my mind, I was wondering if he was staying calm because he was trying to not be noticed by anybody and not draw any attention to himself, because he was holding a pew pew in his pocket. So by this time, the weapon is in his pocket, his jacket pocket. And I don't know if it hasn't come in yet. So it's my understanding that at some point, Dr. Parker makes a comment about like not believing that there's a possibility that there could have been something in his pocket. So something to the effect of, how big are his pockets? That's my understanding of what was said. We will see if that comes out or not. And even if, so I don't know what the minimum Dr. Parker could get. So even if Dr. Parker was convicted, I don't think she'll get 40 years. I don't think she maliciously did anything. So I don't know that the judge would give her the max or anything like that. I don't know what the minimum is. I don't think Dr. Parker should do more time than the mom. Like, if she was convicted, but I do think school administration have a duty to do something if there is a threat on your campus. I think people have the duty to do something. And yeah, it's sad. All right. Yeah. So then there were multiple parents that testified today about their children and the impact of this on their children. The children, many of them are in therapy. They were scared, confused that day. And the state wanted to elicit some additional testimony, some hearsay, and they just gave up. There's like, it's fine. They didn't even try to get the first father that testified to get that in. So then we get to Miss Wright. Okay. Miss Wright was JT's kindergarten teacher, and she retired after teaching him. Okay, Miss Wright. Because when he was in kindergarten, he brought up a chair right up to a student's face. And he was really close to a student, and she just kind of like pushed him, she just kind of, pulled the chair back. He got up and tried to kind of so because she describes what happens, but what ends up happening is she ends up sitting low on the floor in that child's seat. He comes up behind her with both of his arms, and this 5-year-old, okay, content warnings for a 5-year-old doing harm, this 5-year-old chokes her to the point she can't breathe. And my understanding of her testimony was the only way she was able to breathe was because her assistant teacher came over and pulled him off. And he ends up going down to the office, and no administrator is available. So they bring him back to her classroom. Oh, no. No. Miss Wright has been teaching for way too many years. Miss Wright is like, "Oh, no. He's not coming back up in here. He can no." So Miss Wright, I'm being more dramatic than how Miss Wright testified to it, but she was pretty much like, so she made sure that the office, like, no, this is major. I don't care what they're doing. Like, because I think she said something to the effect, because he was brought back with a security person and maybe, let me check my notes, and maybe a counselor, I think, or somebody else. And she was like, no. And the assistant teacher gave her a break, and she went to a lounge to write notes on what had happened that day. She went to write a detailed note of this was his day. And I think she was trying to document what had happened, because she was like, this was a crime. He physically assaulted me. She was sent to the nurse to be evaluated, and made sure that the incident referral form got to the assistant principal and principal. And then he returned to her classroom the next day. She went to the office, went into Dr. Parker's office, and she was like, "I'm going to be the only adult in the room today. Get him out my room or I'm going home." But that was the gist of what Miss Wright said that day. Because the very next day, after attempting to, she could not breathe, he came back into her class and with his breakfast, and she was like, come on with your breakfast. Come on. No, and so he ends up switching schools. Okay. But I think they brought all of this to the attention of the jury because it wasn't when reports of this student having a possible weapon. This was a student that had had a major incident the prior year with his teacher. And so, in my mind, this should have been taken seriously. My personal thoughts. It should have been taken seriously. It's the way Kathy would say it. It's the spirit of what she said. It's not exactly what she said. Kathy is gossip, rumor, and innuendo. All right. And so he never returned to her classroom, and she retired. She did not say that that's the reason, but if I was at my retirement age and I'd be like, "Oh no, this is my last year. Oh yes, this is definitely my last year." I don't know why they gave this student to a teacher that had only been teaching for 2 years. This student had severe behavior problems. He did not need to be with a newer teacher. He likely needed to be in special education, a smaller class with 4 or 5 students, behavior support program, possibly ABA. Really, they needed to address what was happening at home. There were major things. But I personally don't think that placing him in he should have been placed with a more seasoned teacher. And that's in no way. So Mrs. Werner was a great teacher. She did a great job. I think this student could have done this to any teacher, absolutely any teacher. Um, uh, it just it breaks my heart that, Miss Werner, like, she thought she wanted to be a teacher, and she's never going to return to teaching ever again. She might become a hairstylist, like, she's completely switched careers. She was pew-pewed by a student. She's never entering a school ever again, and that's just and they knew, and in my mind, they could have stopped it. They could have done something, anything, and they didn't do much. And so, all right. Um, so he ended up going to another school on read. So the defense kind of asked about, uh did sh- you know did the school system still have a copy of that incident report? Because in the civil trial, I know that after this incident, Miss Wright was like, I still have my notes. So Miss Wright kept a copy, is my understanding. Miss Wright still had a copy of that overview that she had written. And after this incident, she submitted it to people like, this kid had red flags. This kid needed help. Like, that potential threat should have been taken seriously. She still had her personal copy. So the defense kind of asked her about it. And so then the state's like, oh, we would like to admit that. And the defense is like, wait, 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 wait. We weren't asking for that to be admitted. It is what it is. Oy. And so I believe that incident report, that referral form did end up getting admitted. Mr. Rawls' testimony was so hard to hear. Very, very hard to hear. I don't know that he testified exactly because I don't, his testimony in the civil trial, I could hear every single word. He wasn't like, he wasn't speaking loudly. Um, he was kind of further back in his chair, and so I think the jury heard him, but at one point the judge asked him to come closer to the mic, and even after that, like, so there was like a minute where I could hear him well, and then every question after that, it was very difficult to hear. Because I've been following this case and I know the other information, I know that, um, at some point he requested to not be one-on-one with JT all the time, because as a school counselor, he's not a one-to-one. So, like, somebody that's one-to-one with one student all day, they sometimes get a paraprofessional that's normally not your school counselor. So it's kind of a waste of resources. Like, normally you would have, so I've worked with individuals that have had a one-to-one in school, and it was always a paraprofessional, because sometimes I needed to train that individual in trauma informed care, or like sometimes I've had to meet with that individual, or and I used to run a therapeutic school-based counseling program that was in 14 different middle and high schools in our local area, including a therapeutic school. So the entire school was for individuals with emotional disturbances in middle or high school. We did sometimes receive referrals for elementary school students that were expelled. And we would, because somebody else had the elementary school contract. So to work with the elementary school student, I just have to get permission from that company that, yes, we could work with that individual while they were in a therapeutic program. And then once discharged, they were able to return to an elementary school program if that's what happened. But because of my knowledge of those things, I kind of have a different idea. And I also understand how Virginia works. And so that student likely had Medicaid, and he likely qualified for services and programs. So normally a student with that level of behavioral issues, they would have therapeutic day treatment or some type of school-based counseling, sometimes provided by an outside agency. They would often be wrapped with services. It did sound like they had like a team meeting that would talk about his behaviors regularly. Based on Dr. Rawls' testimony, I thought I heard that he didn't quite have an IEP, that they were still working on the IEP, but that he didn't have an IEP yet. Correct? And it was hard to hear, but I thought that's what I heard. You live in Newport News. Welcome, welcome. So, I used to live down in the Hampton Roads area. So Regent University is right in Virginia Beach. And then I also used to live on the other side of the bridge, near Hampton. So like that's Virginia Tech, right over. So it does it backwards for me. So this one right here is Virginia Tech. And then I have my licensure stuff down there. So, because everybody's that calls themselves a doctor isn't a doctor. I did a whole other video on that if y'all want to check it out. Could have done something. Yes, unions are involved because my uncle, I think, so y'all know I have an uncle that was a Newport, and he's a retired Newport News teacher. And there are everybody doesn't have to join the union, but it's my understanding that there is a union. Yeah, so I love living down in Virginia Beach. I didn't get to so I wasn't on the beach side. So when I lived in Virginia Beach, I was closer to Chesapeake. So there's 7 cities. That's the Hampton Roads, Tidewater area. And so even though I lived in Virginia Beach, like I wasn't close. It was like a 20-minute drive to the actual beach. So I didn't get to the beach nearly as often as I would want. And then I moved in with my mom to save some money. It was very hard to hear. Mr. Rawls mentioned SST meetings, but it sounded like they were working on the IEP, but it didn't sound like they had one. Yes. Somebody mentioned that their grandson was receiving therapeutic services through the school. I teach at Christopher Newport. Yes, I used to go to games at CNU. So I ran track in high school, and we would have meets down at CNU. Yeah, Virginia Beach is so huge. 7 cities. Yes, work for Norfolk, for TCC. That is awesome. Tidewater Community College. Yes. All right. So we'll see what happens with this case. So after Mr. Rawls' testimony, there were multiple parents that provided testimony about the impact of this to their children. All of the defense's questions centered kind of around the financial, like, wouldn't you benefit if the defendant was found guilty? If Dr. Parker was found guilty, wouldn't you benefit from that financially in your civil trial? But right now, Dr. Parker has like a 10 million judgment for Ebony, sorry, not for, I don't know me in names, for Abby's Warner. Now she might be covered by liability insurance, and the teacher might be considered one claim, and then the children might be considered a separate claim. So if she has liability insurance, the liability insurance may be the people that will be negotiating things. I don't know how this will affect her personally. I know that like her life will never ever be the same. My heart does break. And the reason why I talk about this is because threats have to be taken seriously. So I've assessed children that have written the school found a list, like a target list, and those students were not able to return to school until they were cleared by a psychological evaluation. And sometimes some students, even once they were cleared with psychological evaluation, they were still referred to our alternative, like they were expelled for the rest of the school year or for the rest of the semester. Because sometimes as that student transitions back into their school, often students at the school know that there was a hit. Like the kids normally know, especially high school and middle school, people know what was going on. And working on talking about what was going on, addressing any concerns, addressing any mental health things. People have to respond to things. You can't just say, I'm focused on testing. Like I'm too busy. And it was tough. I was surprised that we got to see Dr. Parker's Zoom interview with HR. She probably regrets giving that, because I believe she could have declined it. And I don't think she ever thought that she would be held liable for all of this, because it was 2 days after the incident when she gave that Zoom. So it might have been Sunday. If it was 2 days, it was either Monday or Sunday. If it was 2 days later, my understanding was that that Zoom interview was 2 days later. And so I don't think she was being malicious. I don't think it was anything, but intent and impact. And so, as the administrator and as the person, because I think if the principal had known that there was this report, like, that's where, because the principal would have also been charged. So if the principal had known too and didn't do anything, both the principal and assistant principal would be charged together, in my opinion. I don't know that to be true, but that's my opinion. The fact the principal didn't know, she had no clue that all of this was going on. And I think that's why she got fired. Because like, how's all this going on? How are these reports coming in and nobody tells you? Like, sometimes that's looked at as like a failure of leadership. Like, it's like, what's going on? And it's my understanding that the teachers all complained to HR that admin knew that there were problems. I think some of that was kept out. I could be wrong because there were objections and I don't know what's kept out and what's not. I don't even know. I'm going to go home. Mama, if you're still on, I'll be calling you in a minute. Be kind, don't do crimes, and I will see you all next time. Have a good one. Bye.